Cyberpunk 2077 was released a few weeks ago, and we were all excited about it, but it turned out to be something of a dumpster fire. And now as a result, because nothing says Merry Christmas quite like a brand new lawsuit, on Christmas Eve a complaint was filed to open suit against CD Projekt Red, the game's developer, for the whole thing. And there are likely to be more similar suits to come as well. Because this lawsuit is filed as a class action lawsuit, we're actually going to break the subject down into two videos. In this video, we'll go over the claims of the lawsuit that was filed and what the plaintiff needs to prove in order to win. In the next video that'll follow right after this one, we'll go over how a class action actually works. Coming up on Legal Bytes. Hey everyone, welcome to Legal Bytes. I'm Alyte, I'm a lawyer, and on this channel we explain the law one bite at a time. So if you don't know about Cyberpunk 2077, you definitely are not a gamer, and you probably don't live with one either. It's a game that's been in the works for like 7 or 8 years and managed to even get Keanu Reeves to star as one of the main characters. The release was delayed several times, but even still there was so much hype about this game before it came out, and my husband and I were so stoked to play it together on PS4 Pro. And by play it together, I mean my husband's hands are actually on the controller, but I'm telling him what to do and where to go and all that kind of stuff. Kind of like a Jeff Koons art piece.
They're created through systems that I'm responsible for each and every mark.
So it doesn't matter that you don't physically touch the canvas with a brush?
I am in a way physically doing it, but it's physically through all these systems. But it's like articulating your fingers and, your mind is telling the finger to do this. So at the end of the day, that mark is as if I would sit here and do it myself.
I'm not usually the one that's physically doing the thing, but I'm watching and overseeing. Basically, I'm Jeff Koonsing the game. Is that a term? We're gonna make that a term. But anyway, after reports came out that Cyberpunk 2077 was a huge buggy mess that kept crashing on people, we decided that it was better to put the game back on the shelf until CDPR fixes it well enough so that it's actually likely to be enjoyable to play the game. So now that we're not likely to actually play Cyberpunk 2077 until, I don't know, maybe 2077, we're just disappointed. But that does not mean that I can't give you an unbiased analysis of the lawsuit filed by fellow members of the California Bar at the Rosen Law Firm. So with that, let's get into it. Oh, and before we do that, shout out to YouTube account Declan for giving a nod to us to cover this topic. I could have sworn I also remembered someone else in the comments on one of the previous videos also recommending that we talk about Cyberpunk 2077, but for the life of me, I could not find it when I went back. So if that was you, thank you for reaching out, and thank you to Declan, and I really hope that I'm pronouncing that correctly, for the nod. We were for sure already going to be looking at this case, but it's always great to get confirmation from viewers that we're looking in the right direction. Okay, back to the lawsuit. Let's take a look at this complaint filed on Christmas Eve. By the Grinch? For the Grinch? I think it depends on your perspective. So there are two main claims to this lawsuit. The first count is a claim that CDPR and the named individual defendants violated Section 10B of the Securities Exchange Act of 1934 and SEC Rule 10b-5. I'll spare you the history of the Securities Exchange Act of 1934. This time anyway.
All right, Simpson, you win this round.
Basically, the relevant language here says that it's unlawful for anyone to manipulate or deceive investors regarding the purchase or sale of any securities or stocks that are sold on public exchanges. Essentially, if your business is on the stock market, the law says that when you're talking about the things that indicate the value of your business, you can't lie about it, either by explicitly saying something that isn't true or by failing to say something that's necessary to give a truthful impression of the situation. Now, because we're talking about deceit here, there has to be some proof of what's called scienter, or basically a mental state. In other words, the plaintiff is going to need to show that either the defendants knew what they were saying was false, or that they were at least reckless as to the truth or falsity of the statement that they were making. So if it turns out that they had a good reason to believe in what they were saying, then it's likely not enough to win on this claim. On the other hand, if evidence comes out showing that they wrote emails to each other talking about how they needed to cover up something important, then that's helpful to prove this mental state and to prove the claim. Okay, so aside from scienter, then the plaintiff also has to show that he or she relied on that statement and that they were somehow harmed as a result of relying on it. Here, the claim is that the investors relied on the statements made about the future release of Cyberpunk 2077, and that they then invested in stocks in CDPR, and that as a result, they were harmed when those shares dropped in value because of the release's disaster. It seems to me that it should be fairly easy to prove the losses that were incurred by investors whose shares recently plummeted. Anyone can look at CDPR's stock since the release of Cyberpunk 2077 and see that it lost a lot of value in the days that followed. Okay, on to count number 2. The second claim that the plaintiff makes is a violation of Section 20A of the Securities Exchange Act. This one is what's called a derivative claim because it relies on the success of another claim in order to succeed. So if count 1 fails here, count 2 also fails. But if the first one succeeds, all it takes is proving a little bit more in order to succeed on this one as well. To make it a little more concrete, basically, this statutory language says that any individual that either directly or indirectly causes the deception of investors in count 1 is held jointly and severally liable for the deception. What that pretty much means is that the whole group of people involved in the deception, regardless of whether, let's say that there was a ringleader who pushed for the deception, the court will still treat everyone as having the same level of liability, and the plaintiff can reach any and all of their pockets just the same. So we'll focus on count 1 here because that's really where the meat and potatoes are for this lawsuit. Basically, there are 3 ways to fall over the tripwire of count 1. The first is by employing any device, scheme, or artifice to defraud investors. This basically means setting things up in a business so things don't appear as they really are. An example I could think of is maybe creating a system of fake reviews for a product, making it look like it's more popular than it really is. Obviously, this wouldn't apply to just any product. This is for products that are sold by a company that's on some stock exchange somewhere. The second way to fall over the tripwire here is to either make any untrue statement of a material fact, meaning it's not an untrue statement about something no one cares about, it's a statement about a really important part of the product or the condition of the company, for example. Or the other part of this one is to omit a material fact that's necessary to make the statement true. An example of a false statement by omission would be if you turned to your spouse and said, "Honey, I love you so much, and because I love you, I decided to buy you a car for your birthday." But let's say that you neglected to tell your spouse that you didn't buy him or her a car that can be driven on the road, you bought them a toy by Mattel. It's technically true, you bought your spouse a car, but you omitted the detail about whether or not this is something that your spouse can actually drive. Details matter here. Anyway, the third way is to engage in any act, practice, or course of business that is deceptive or would be deceptive to any person. In other words, probably something like, I don't know, a Ponzi scheme. Something where the entire business pretty much involves lying and where anyone getting involved at any surface level would have fallen victim to it. So in this case, the complaint basically alleges that CDPR, through 3 of its corporate heads, misled investors by making a series of untrue statements, and that they made these statements either intentionally or with reckless disregard to the truth or falsity of the statement. And as I mentioned earlier, the complaint also alleges that investors relied on those statements when they bought stock over the past year, and that when the game launched and everything failed, they suffered harm because CDPR's stock basically plummeted. The complaint basically points to 4 or 5 different statements made by the different defendants. And when you look at these statements, don't just think, did they end up being wrong? Think critically about whether or not there was a lie in that statement at the time that it was made. I'll mostly paraphrase the statements here, but keep in mind that they also need to be taken in context to see whether or not they give an overall impression that's unfair or misleading, or whether they maybe actually believed the statements that they were making and had good reason to believe those statements. If you guys want to see the quotes that were specifically used verbatim in the complaint, I'll link to the document in the description below. So the first statement highlighted in the complaint was made on January 16th, 2020, when CDPR announced for the first time that the game was not going to be released on time. Instead of April 17th, 2020, the game would be released on September 7th, 2020. However, in that statement, CDPR assured everyone that the game was, quote, complete and playable, unquote, but that CDPR just needed more time to finish playtesting, fixing, and polishing. This is probably honestly one of the stronger statements that's highlighted in this complaint. That said, it still really comes down to an interpretation of the words complete and playable, and it also depends on whether the part about still needing time to fix it, polish it, etc. modifies the statement enough that it's essentially a truthful statement. I can see many people saying that it was complete and playable, and many others saying that it definitely was not. Since we refuse to take our copy off the shelf until it's better, I haven't touched it other than what I've seen on YouTube. So I'm curious to know what you guys think about this statement. Was it true at the time? Was it misleading? Let us know in the comments below. Anyway, other statements they mentioned include one on April 8th, 2020, where they delayed the release date another 10 days and justified it by saying they needed additional time to fully playtest, bug fix, and polish the game, thus ensuring that customers receive a top quality product. Honestly, I don't really see a lie in this statement. They said that they needed more time so they could fix things and give a top quality product, which actually seems to be pretty true. Obviously, it didn't end up a top quality product, but you can tell by the context there that it's more of an aspirational statement than anything else. And if you disagree, let us know in the comments below. Anyway, then the complaint points to September 4th, 2020, when they delayed further to November 19th. There, they said they were preparing for final certification by Sony and Microsoft, and they said everything was on track for November 19th. This one, on its face, also could go either way, honestly. As we know, Sony and Microsoft actually did end up certifying the game. However, other statements that have come out recently also seem to indicate that the certification was kind of fudged a little bit. That said, you can also have a product that is on track at one point and that falls off the rails later by some unforeseen circumstance. Or maybe they knew they weren't on track, but were hoping that they could somehow get it back there through, I don't know, sheer will or something. One thing to point out here is that this statement, and probably most if not all of the statements highlighted here, will also need to be compared with information as to what was going on behind the scenes. Particularly, what did the defendants know about the game at these various points in time? Were there any surprises along the way during development? Were there any conversations between each other trying to cover up material information? That's all information that will likely become available during the discovery process of the litigation. And when I say discovery, I mean the phase of litigation where both sides are getting information from one another. This is where the two parties request documents like emails, memos, meeting notes, etc., and where they take people's depositions like you'll see in the movies. Now, another thing that I want to point out here is that a general thing I noticed is that a couple things here and there basically give the impression that the lawyers writing this complaint aren't really gamers and haven't really been following the situation, because there were a couple facts that I was actually kind of surprised that were left out of the allegations here. For example, one big one was the fact that CDPR prevented reviewers from using footage from current generation consoles, meaning PS4s and Xbox Ones, until after the game was released. At the time, it seemed like most people just looked at that detail as just some oddity. But little did we know it was maybe because CDPR was, I don't know, hiding the ball a little bit, maybe being a little bit deceptive. Really, it's hard to look at that part and say that CDPR probably wasn't being sketchy about it. And that act, the preventing reviewers from using certain footage, could be perceived as a device to defraud, as highlighted by the first one of the 3 tripwires under SEC Rule 10b-5 that I mentioned earlier. Also, if you've read the complaint, you may have noticed that there are a couple small errors here and there, and then there appears to be a bigger error in one of the paragraphs, specifically paragraph 26, where the logic in the argument doesn't really follow from A to B to C, etc. I won't go too much into detail there, but if you're interested in seeing what I mean in more detail, link to the document is in the description below. You can go check it out. My intent in pointing this out isn't to be some a-hole to another member of the California bar.
What a bunch of a-holes.
This is more to point out that lawyers can make mistakes too, and particularly when under a time crunch. Given the fact that this was filed on Christmas Eve, I'd say it's way less likely that they filed it that day because they wanted to do so. It's more likely that they were just racing to get it filed, and that's sometimes when you can have some mistakes. That said, as a baby lawyer, I learned from some very good litigators that mistakes, even little ones, can start to chip away at your credibility. I've made plenty of mistakes myself, both in drafting documents and in making videos, and every time it is like super painful to find. But basically, back to the lawsuit, it's not exactly a perfectly drafted complaint, but that doesn't mean that it's going to fail. If it's bad enough that it needs to get fixed, it can be amended and resubmitted. Okay, so that's the first part on this lawsuit. Next up is a video on the class action part. If you're interested in learning all about this lawsuit, look out for that video. It should be coming out as soon as possible after this one. Otherwise, I hope you enjoyed this or at least learned something. And if you did, we'd love it if you could like this video, subscribe to the channel, and hit the notification bell so you can see more content just like this. See you in the next video.